is eager for me to make a bond argument for his release. He was in treatment. I don't have that documentation. I'm going to follow up to try to get it. I obviously I want to advocate for his release, but I know it's important to have the documentation verifying what he's saying, which is that he did actually complete the treatment.
I'm going to have another copy at the house.
So I'll follow up with Mr. Dunlap about that. In terms of the PCC, Your Honor, at this time, prosecuting attorney and I have had some communication. There's no offer at this time, so we would ask that it be set for exam.
Discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available on the 16th.
Yes, Your Honor.
Preliminary examination in person, September 16th, 2025. 9 a.m. That is before Judge Washington. At this time, bond will continue.
Thank you, Your Honor.
Court does call the case People versus Larry Atkins.
Calls for people.
I know, because she's not here. Your name, sir?
Larry D. Atkins.
Thank you. Where is Akinruli?
We're grabbing it right now, Your Honor.
Not forcefully enough.
Understood.
No, take your time.
I apologize. Assistant Public Defender Chinazi Perry, really, Your Honor, on behalf of Mr. Larry Atkins. Mr. Atkins, have you already stated your name for the record?
Yes.
Okay. Your Honor, we are
This
asking.
whole story of his life by the time you got here, but go
I
ahead.
was gone that long. I'm sorry, Judge. We are asking for an adjournment in this matter to gather mitigation information.
You have a green sheet.
I do, Your Honor.
You're filling it out now.
I am, Your Honor.
Yeah. Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continue. Slow.
Thank you, Judge.
Thank you.
Yes.
Court calls case People versus is it Jaquez Gully?
People, Your Honor.
Apologies. Laura Yagi, Assistant Public Defender with and on behalf of Mr. Gully. Mr. Gully, can you state your name for the court?
Jaquez Gully.
Thank you.
I apologize, Your Honor. We're asking for an adjournment. Mr. Gully indicated he's going to retain counsel or he's in the process of retaining counsel.
How long is that going to take you?
2 weeks.
One adjournment for that purpose. Probable cause conference, September 18th, 2025, 9 a.m. Bond continue.
Thank you.
Court calls case People versus Jamie Bailey.
Laura Yagi, Assistant Public Defender with and on behalf of Mr. Bailey. Mr. Bailey. Your Honor, I was going to request an adjournment. I have a green sheet. We did receive media discovery yesterday, and I haven't had time to review it with Mr. Bailey, so
Because he's not here.
apparently is not.
That warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately. Yeah. Court does call the cases of the People versus Demond Harris.
Preliminary exam scheduled, September 16th, 2025. This is where the prosecutor must show enough evidence to move forward. Think of it as a legal filter. Weak cases often die here. Would you rather see these live in court or on Netflix?
Hello, Judge. Brian Bowling on behalf of Mr. Harris, who's approaching. Name for the record.
Harris.
Judge, I'm asking for an adjournment so that we can have some ongoing plea discussions in this matter.
Is this the only thing holding him, or?
No, there is other matters, Judge.
All right. Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls case People versus Christopher Minor. Custody.
Good morning.
May I vote for the people, Your Honor?
Good morning, Your Honor. Kerma Tadish on behalf of Mr. Minor. Mr. Minor, are you able to sit down on the chair?
Yeah.
Yeah, could you? I asked the wrong question. Thank you. Can you state your name for the record, please?
Minor.
Did you need his full name, Your Honor?
That's Mr. Minor. We'll go.
All right. We still have outstanding discovery, Your Honor. We were going to ask for an adjournment, please.
All right. Is this the only thing holding him?
No, it's not.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right. Thank you, Mr. Minor. Let's call the case People versus Dominique Kelly Payne. Dominique.
Assistant Public Defender Jay Bellinger on behalf of Mr. Kelly Payne, who approaches, Your Honor. Take your name for the record.
Dominic Kelly Payne.
And Your Honor, I have supplied the court with a waiver form.
Yes. Sir, you're waiving your right to a preliminary examination?
Yes.
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 You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 3 with 4 following.
Your Honor, people acknowledge, I'm sorry, not the people. Defense acknowledges receipt of information, wait for repeating and stand mute.
Defendant having waived for reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 16th at 1:30 with Judge Simpson.
September 16, 2025, 1:30, Judge Comfy.
That'll be me, okay?
Yep. Thank you.
Bond will continue.
Thank you, Your Honor.
Thank you. Let's call the case People versus Kayla Baird.
Assistant Public Defender Nazi Carey, really on behalf of Caleb Baird. Judge, can we pass this matter?
No.
Ms.
Why?
Baird is present. I asked,
What?
she is here. I asked her to go to community corrections to test because she had not done so. So she's over at community corrections now.
She tested.
She lives in Flint now. She's currently displaced and she tells me that she lives in Flint and she did not have a way to get down here to test. Thank you, Your Honor.
Court calls case People versus Melissa Konwinski.
Chelsea Virgils with and on behalf of Melissa Konwinski, who approaches. Please state your name.
Mary Konwinski.
All right. What are we doing?
Your Honor, we're asking to adjourn to continue a plea discussion, and I would ask to address bond.
Of course you would. Is this the only thing holding her?
Yes.
Adjournment granted to gather mitigation. Translation, defense is buying time to build a softer narrative. Job, treatment, family obligations, anything to reduce punishment. Smart move or just another stall?
Probable cause conference will be adjourned September 18th, 2025, 9 a.m. Yes, to bond.
Your Honor, we're asking for a personal bond in this case. I understand she did have a violation, but she has a thorough plan to maintain sobriety, including through CMH, both substance abuse and mental health treatment. She has an appointment set up with them already, including also the Vivitrol shots involving with her church. She goes to AA. She's really worried about getting out to work. She supports herself financially. And I think that this plan can set her up on the right track. So we ask you to consider that.
What is the plan? That's the plan?
Yes, treatment, AA, church. I think all of those things would be a great support system for her. And she did just get out of inpatient treatment recently, so that is fresh in her mind. She wants a chance to show the court that she will comply.
She got out and then 2 days later, she's violating her tether.
It was admittedly a relapse that she deeply regrets.
Response from the people.
Your Honor, when we talked about this last week, I reminded the court that this was a hit and run with an alleged BAC of a .28. I'm not saying that Ms. Kowinski is somebody that needs to be in jail indefinitely, but I do think that we'd like to see it a little bit more concrete in any release with this grand tether.
Your Honor, may I respond briefly?
Go ahead.
I just wanted to point out that the incident allegation in this case was before her inpatient treatment, so she sought out that treatment herself. We have no objection to a scram tether, but I think that
Didn't
this,
she have a program for follow-up care after her treatment?
I believe so. I think that part of
Is
this
she
plan.
following that?
Are you following your plan?
Yes, I am.
And I think this is fairly
Oh.
concrete. She has an appointment on September 22nd.
After she got out of treatment, she was supposed to, there's another part of what her treatment would be. Did she continue with that?
What was the plan after treatment?
The plan after treatment was to go into IOP, which I did call CMH, but unfortunately, there was no opening until the 22nd, so I can have a 90-minute evaluation so I can get an IOP. I am still following up with Michael Francis, which is an outpatient psychiatrist in the meantime, until I can get in there on the 22nd.
So the answer to my question is no, she didn't follow up with that. And then secondly, then again, 2 days after that, outside of the facts of the particular case, she was drinking again. So, and I'm not really hearing a concrete plan that's consistent with the inpatient that she received. So for those reasons, the court is going to deny the request for a bond. In this case, bond will continue. Court does call the case of the people versus Jennifer Baker.
Question calls for the people.
Assistant Public Defender Jay Bellinger on behalf of Ms. Baker, who approaches, Your Honor. Baker, can you please state your name for the record?
Jennifer Baker.
Your Honor, you first.
Yes, you may.
No show? Bench warrant drops $10,000 cash bond. That's the court saying, skip again, and you're not walking out unless you pay hard money. Fair warning, judges don't play around with attendance.
Probable cause conference will be adjourned to September 11th, 2025, 9 a.m. Bond continued.
I had to come back a third time.
No, and Your Honor, I just want to make clear on the record for Ms. Baker's purpose that if this case is dismissed, in fact, and I talked to the prosecution about that, you will not have to come back for the dismissal to issue. Okay? Is that correct, Your Honor? I just want to make sure that.
Sure.
Okay.
No, she doesn't have to come back
Okay.
because of the reason why there would be the dismissal. I wouldn't want to. All right,
Okay.
thank you.
Okay.
So we will figure it out. Okay,
Wow.
all right.
Court does call the case, People versus Demarion Makowski Smith.
Morning, Your Honor, Raymond Cook for the people. Good morning, Judge Cottrell, on behalf of Demarion Makowski Smith.
Assistant Public Defender Alexis Zerbs, also with and on behalf, Mr. Makowski Smith.
Good morning, Your Honor. Demarion Cortez Mikowski Smith.
All right. What are we doing?
Your Honor, there should be a green sheet submitted. We are respectfully requesting an adjournment just to discuss his options with him. And to this.
Are these the only things holding him?
Your Honor, if we can make a minor request, he's currently awaiting an MDOC tether for a circuit court case that he's on probation for a home confinement tether. He saw the visiting judge for Judge Conlon yesterday. He turned himself into the jail yesterday morning on that warrant, got that violation taken care of. They granted him the PR with the MDOC tether with home confinement. So we would be asking if the court would consider removing his tether for his bond on the CCW case, considering he'll already be monitored with the MDOC tether.
But we will get that information.
And that's what I was explaining to him, Your Honor. We just would make that request because it does seem a little redundant that he's going to be home confined twice.
And Your Honor, if I may add, Mr. Makowski Smith has been very communicative with me on during my course of his representation. As soon as he was instructed to turn himself in, he called me immediately to let me know what he was doing and that he was about to turn himself in. So he's been very communicative, and I've every confidence that the court will be able to.
He's got 2 legs, so we can put a tether on each one.
Understood.
Is that right? I mean, I'm just saying.
That's what it have to be. That's what it have to be, Your Honor.
And understood, Your Honor. I did have that conversation with him as well.
If we can get communication from MDOC, I don't mind releasing ours, but I'm not going to release our tether until I have that assurance that we'd have the information.
Understood, Your Honor. We can see if that is a possibility.
All right, so that request regarding modification of bond at this time is denied, but if they get that information, then we'll figure it out. Okay? Thank you. Oh, it's the 18th.
Thank you, Your Honor.
Court does call the case, People versus Taiwan felon.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Phelan. Hearing via Zoom. Mr. Phelan, will you state your name for the record?
Juan Phelan.
Thank you, sir.
Your Honor, may we approach?
Yes.
For that bench conference, we are asking for an adjournment on Mr. Phelan's case for some continued plea negotiations.
All right. Probable cause conference will be adjourned the September 2025, 9 a.m. Would that be enough time?
I think so.
All right.
Thank you.
Bond will continue. Court does call the case People versus Melvin Morrow.
And Laura Yaki, Assistant Public Defender, with and on behalf of Mr. Morrow, who's approaching. Would you state your name for the court?
Melvin Morrow.
Your Honor, I apologize. I do have two documents, one signed exam waiver and one request that Mr. Morrow be released to treatment. I did provide a copy to the prosecutor.
It would allow him to release to treatment.
Thank you, Your Honor.
He's waiving exam.
Yes, Your Honor.
That's correct, sir?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Young.
We waive formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 16th at 1:30.
September 16, 2025, 1:30 before Judge Kunke. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Dominic.
Trevor Maybell for the people, Your Honor.
On behalf of Mr. Brewer, who is here with me, can you please state your name for the record?
Dominic Brewer. Thank you.
Your Honor, we're asking for a 3-week adjournment so we can continue plea negotiations.
3 weeks?
Yes, if Your Honor is so inclined.
3 weeks? Why?
Because I'm on vacation and he has requested that.
So we all have to wait for you to get back?
No, I can do my work before my vacation
You're gonna do it before the vacation, then why am I giving 3 weeks?
because it's unrealistic that I complete what I need to do for his case before my vacation starts. Your Honor, I have full faith in my PD team that if it gets adjourned 2 weeks, that they'll do even better than I would on his case. But I'm just trying to get his request in. Yeah.
I don't worship.
Into a bench conference.
September 25th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thanks, Mr. Brewer. Take care. Court does call the case People versus Megan Moses.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Moses, who approaches to my right. Ms. Moses, please state your name for the record.
Megan Moses.
Your Honor, today is the date time set for probable cause conference.
It is.
At this time, there was an agreement in place. So we're going to be asking for an adjournment of this probable cause conference and some consideration on bond later on.
Okay. How much time did you need?
Let's start with 3 weeks for the adjournment.
Okay.
All right. We're going to go into the bond.
Yes, go ahead.
So, Ms. Moses, I believe she was here last week. She had turned herself in. She had issues both with her tether, being able to get a Zoom date. When she appeared here, there was a question about whether or not she had communicated with our office or with anyone concerning the issue she was having. The attorney who was standing in at the time, I don't think was able to let the court know that Ms. Megan had in fact been in contact with her. She let us know. She did let us know that she had issues. We have file information from August 20th, where she contacted us concerning the issues she was having concerning her phone and her tether. So I understand that one of the things that the court was concerned about was that she did not have communication with us. And that's just not the case. She did communication with us. There are file notes that indicate that she did contact her office. More importantly, she did turn herself in. She came into her court date. She was here. She was present. So what we're asking is that not only that she be released from jail during this interim period, because part of what we're trying to do is to get her in a situation where she can pay restitution for this matter, without giving away too much. So we want to be able to get her out, get her employed, and get her to making payments. And so that comes to the second part of what we're here to ask.
What day did she turn herself in?
Last Thursday.
Last Thursday. And she came here, she came to court and then she was taken into custody. She was remanded when she came to court. So she
Right.
came here.
With the tethers.
Okay. Because I think I did address most of that yesterday with the last time that we were here, but response from the people.
Your Honor, ultimately leave it to the court's discretion. I can't say what communication she had with her attorney. Obviously, I'm not privy to that. My concern is I do think that she does need to be out in order to make that restitution payment. That is sort of the contingent basis of this plea negotiation. Whatever steps the court feels it needs to take in order to monitor her. So no objection to that, but I think that some form of release might be appropriate, given that we need to have that payment, because you can't do that in custody.
Right, but the problem that I'm having is typically